SwayamPrabha. Digital India. Educated India.
Welcome students in the class of Transfer of Property Act. Myself Dr. Amrendra Kumar Ajit from Faculty of Law, University of Delhi. This is my 18th lecture and this lecture will be on gift. Earlier I have discussed lease and rights and liabilities of lessor and lessee. So, gift is also a kind of transfer of property from one person to another, but one thing is very peculiar in this. This transfer is without any consideration. Okay. In rest of the cases, that means rest of the transfer of property, we have seen that consideration was must. But here in case of gift, consideration is not important, okay, as well as it is also different from mortgage, sale and lease, that in mortgage, sale and lease, there is transfer of only immovable property. But gift is different from altogether. Gift may be of movable as well as immovable property. Okay. So, two peculiarity in gift is, first is this is a transfer of movable or immovable property without consideration, okay, which is not in the case of other kind of transfer of immovable property. Okay. So, now let us start the chapter of gift, its modes, suspension and revocation. So, first I will start with the definition. Okay. Section 122 to 129 is mainly devoted to gift. Okay. And according to section 122, gift is a transfer of certain existing movable. Certain is also here an important word. Okay. So, certain existing movable or immovable property made voluntarily and without consideration by one person called the donor. The person who is making the gift will be called as a donor. To another person who is receiving that gift is donee and accepted by or on behalf of the donee. That means, donor is going to create gift or going to do gift and receiver is donee, and receiver may be a person who is receiving that gift on the behalf of the donee. Okay. So, donee may be the person to whom the gift has been given or any person who is authorized to receive on his behalf, that is that person may also receive. Then further this 122 says that acceptance when to be made, that means when it will be treated that gift has been accepted. So, it says that the such acceptance must be made during the lifetime of donor. Okay. That acceptance of gift must be made during the lifetime of donor and while he is still capable of giving. If the donee dies before acceptance, the gift voice. Okay. Donee dies before acceptance. That means, in the both the case, because first it is saying that when must be made during the lifetime of the donor, or while he is still capable of giving. That means, gift must be accepted within the lifetime of donor and within the lifetime of donee. Then only, otherwise death of any will make gift void, okay, because the gift which has been accepted after the lifetime of donor, that will be also void. Okay. So, what are the essential of gift? The first is, gift is a transfer of certain existing movable and immovable property. So, it is a kind of transfer and certain existing movable or immovable property. So, certain existing is different essential and movable and immovable properties different essential. Okay. Made voluntarily and without consideration, again these are two important consideration within the essential itself, by one person, that is donor, accepted on the behalf of the donee. Then such acceptance must be made during the lifetime of the donor while he is still capable of giving, and if the donee dies before the acceptance, the gift is void, what I have already discussed in the definition of gift under 122. Now, one by one. A gift is a gratuitous transfer. Gratuitous transfer is without consideration. Okay. That means, it is a one-sided transfer. It is not a transfer from both the sides. Okay. Only the donor will transfer the movable or immovable property to the donee, and donee does not require to give any kind of consideration to the donor. So, here consideration is 0. So, even this is a valid transfer, without consideration it is a valid one. So, in gift an existing property is transfer, that is very important, existing. So, here certain existing, okay. So, existing property is transferred in favor of another person without consideration. So, this existing is very important. Then a gift may be made between two living person, or it may take place after the death of the transferor, testamentary, or it may take place after the death of transferor. So, that is a testamentary gift, okay, in that way. So, Noor Bhanu versus Abdul Amis Bhuiya, it has been said that the mental capacity of donor is a question of fact. Mental capacity of the donor is a question of fact, that whether the person is competent to contract or not. Okay. And if this competent or not, that means whether his mental capacity is to that extent to take a decision, free decision or not, that is the question of fact, and it will be determined by the behavior and all other conditions, medical condition and all will be taken into consideration. Then it is decided what is the mental capacity of that individual. So, in this case, the lower court in this case had recorded a finding that the donor was mentally sound and capable of executing the deed. The court said that this finding could not be interfered with the second appeal. Okay. Second appeal, because this is not the question of law. When the question of fact has been already determined, okay, and this question of fact is already recorded by the district judge, in that case this may not be appealed further on the ground that this question of fact should be again decided. So, deed was duly registered, because according to the district court, the person who was executing the deed was a sound person, and he has already executed that deed. So, that deed will be the valid one. So, that deed was duly registered and proved by evidence of the attesting witness. Yes, because once the witnesses are also ascertaining that he was a sound mind at that time, there is no question of doubt. No conspiracy element was proved. The suit also filed after 3 years, and therefore, that was the time bar. Okay. So, the mental capacity of the donor is a very important. Okay. Generally in the cases of testamentary gift and all, okay, that create a problem that at the time of making that testament, whether the mental capacity was mental capacity of the old man was proper or not. Okay. So, it should be decided by the court after taking number of evidences, and once he is reaching up to the conclusion that no, the circumstances, evidentiary value, all those suggest that it is a kind of the person was in the proper mental state. So, that is the final, the question of fact has been decided. Come to the element of gifts one by one. There must be a transfer of ownership of property. When it is a transfer, this one gift is a transfer of certain existing. So, this transfer is not a transfer of limited interest, okay, like in the case of mortgage, lease and this mortgage and lease. Okay. So, this is a complete transfer of the ownership like sale, okay, but in sale there is a consideration, here there is no consideration. So, gift necessarily involve the transfer of ownership and not only the transfer, complete transfer of ownership. Okay. In this, the whole of the interest of the person in property is transferred in favor of another person, that is donee. Okay. The person transferring the interest is known as donor, and the person who is against whom to whom that interest has been transferred, that person is called donee. Donor must be competent to contract, and mental capacity of the donor is a question of fact. I have already discussed it. Then come to the gift of whole property or by part. Okay. Gift of whole property by part owner. So, when we are transferring any gift, transferring, that means when we are, any person is going to give gift, and gift may be movable or immovable as of immovable property. So, suppose any person is transferring gift or putting a gift agreement of his own share in a joint property, okay, whether he can do that or not, or first, second is when a person is going to give whole property where he has only the share in that property. So, in first case there should not be any problem, that if I have a share in this particular house 1/4 share, then I can gift 1/4 share to anyone. Okay. But if I am the sharer of co-sharer of this house, then whether I can do the transfer in the form of gift to the whole property? Certainly not, we cannot do in that way. Okay. So, in Anita Verma versus Saroj Devi, this is a case of Patna High Court. A widow had a limited interest in the property. Okay. Widow has a limited interest because widow will have co-partnership right, so this right under the Hindu joint family. Okay. Certain share certainly she used to get, but during her lifetime she made a gift of the entire property and delivered possession. Okay. That means she gifted that property beyond of her share. Okay. So, it was held that the successor were entitled to recover possession because the gift of the whole property was a nullity. Okay. That means complete, that gift will be complete a void agreement. Okay. Suppose I have only this share, or any person, here in this case the lady is widow lady. Okay. So, only suppose she had only 25% of share in that particular house or any property, including all property 25% share, whether it is a land, house or whatever it may be movable property. Okay. then she transferred as a wool. This building has been transferred or gifted to person X. Okay. And there were other co-share in the property, that is A, B, C, where the co-sharer of the property. So, certainly they will need that their share must be divided. Okay. Or sometime it may be that this widow lady has already gifted that property to someone, and the co-sharer in that, the co-sharer may be her son, daughter, or any near relative of her husband. So, they will ask their share, then because she has transferred the share of others. So, in that way it will be complete a void agreement of that. So, gift itself is complete a nullity, and that will have no force in law. No one can do that. So, complete owners, what is the meaning of here transfer? Because the person is going to transfer the ownership, and if you will remember the lecture of cell, or you might not have seen, then no one can transfer better than what he has title over that. Okay. So, owner cannot transfer something more than the ownership, and owner cannot transfer something less than the ownership in case of sale or gift. Okay. Because this is the, I am not talking about the mortgage or lease, because there is transfer of limited interest. But in case of gift, if something is going to be gifted, then there will be complete transfer. So, in that complete transfer, that what is the right of that person, okay, over that property, that is very important. So, a person will have only right over his own share. So, he cannot transfer something more than the share what actually he is entitled under law. Okay. And that property must be in existence. Okay. So, here it has been said that the gift could not bind the reversioners during her life, but not afterward. Okay. Not afterward. The reversioners were entitled to file a partition suit for their share in the property. Okay. Gift could not bind reversioner during her lifetime. That means, whatever the obligation has been created by gift, that will be not binding on the reversioner. Who are the reversioner? The person who are the co-sharer in that, who are left. Okay. So, they are reversioner here. So, that is not binding on those co-sharer who are left under this agreement, as well as it says that the reversioner were entitled to file a partition for suit of their share in that property. Then the third person cannot challenge the execution of gift by a co-sharer in favor of her son. That means, here the third person cannot challenge the any kind of transfer through gift. That means, whose rights are going to be affected, that person may file suit, or the person to whom it has been given, that person may file suit, because that person interest will be also affected, but not any third person. So, suppose take the example again of this case, then here is only 5 parties, W, A, B, C, and to whom X has been X is the donee here. Okay. So, donee will have interest in that property, ABC will have interest in that property. So, suit may be filed by the legal heir of X or ABC or their legal heir, not by any other person. Okay. So, in Geeta Devi versus Kameswar Chaudhary, this is also the Patna High Court case. It has been said that third person is not entitled to challenge the execution of gift. Okay. Then second element is existence of property. That means, the property which is going to be transferred, okay, whether it is movable or immovable, on the date of transfer, property must be in existence. Okay. It is not about that something which is going to be promised as a gift which is not in existence and which will come later on, that thing cannot be the part of gift. So, for a gift it is necessary that property must be in existence at the time of making gift. Okay. Although its conveyance may take place either in the present or in future, both the types of properties, movable or immovable property, may be gifted. So, whether it is movable property or immovable property, nature of property is immaterial in the sense that this nature of property, whether it is movable or immovable, it must be in existence on that date. Okay. So, someone will tell that okay, this conveyance may take place either present or in future. Okay. Conveyance may take today itself or in future also. So, it is not about the past transaction. Okay. That means, gift is on the present date or for the future conveyance may happen, but property must be in existence. So, someone is saying that okay, I will gift you one bike on your birthday. Okay. Then this is only promise to gift. This will be not treated as gift. Why it is not treated as gift? Because bike is not purchased yet. Okay. That means, when the gift is going to be made, at that time property must be in existence. Future property cannot be the subject matter of gift. The property which is not in existence, that cannot be the subject matter. The crop, that means next year crop may cannot be the subject matter of the gift. Okay. So, in that way it cannot be gifted. A gift of a future property is completely void. Section 124 provides that a property must be in existence at the time of making gift, otherwise gift will be void. So, the property is not in existence, in that case gift will be void ab initio. Actionable claim is an existing property and it can be gifted. Okay. Actionable claim on property is a kind of existing rights, okay, or it is a kind of property. Actionable claim is an intangible property. Okay. So, this intangible property, actionable claim, will be treated as it is a kind of right which can be exercised, okay, and in that way it is in existence and it can be gifted. Okay. A gift comprising both the existing and future property is void as to the future property. Okay. This is also very important part, that if any gift is of the combination of movable, immovable as well as existing and future property. So, in that case what will happen? Whether the total agreement will be void because the future property cannot be the subject matter of gift. So, here rule is that gift will be valid to the extent for the existing property, not for the future property. Okay. So, take the example that someone is going to gift a house and this house is going that means whatever will be purchased with a promise that in future the rest of the item it is going to be purchased in next 2-3 years and whole item will go under the category of gift, and later on in subsequent years it has been purchased also and that has been given into that particular house. So, suppose A has transferred these things to B, then A here is going to claim later on that whatever it has been transferred. Take the example in a better way, that if A has transferred on 1st January 2024, that okay, this house is going to be gifted, and whatever the property up to 1st April 2024, this number of stuff will be given into that house, and then that will also be the part of the gift. But the gift was executed on 8th January 2024. So, whatever property is coming in between 9 January to 1st April 2024, and suppose all properties value is approximately 5 lakh rupees in that, and that is going to be challenged by A legal heirs. Okay, A legal heirs. Then in that case, what is the gift amount? So, total gift amount up to that was, it was 25 lakhs with all material which was in house, including the land value as well as the house value plus some stuff. So, 25 lakh rupees. These 5 lakh rupees later on came. These 5 lakh will not be the subject matter of gift here. Okay. And if his legal heir want to challenge, because whatever the gift has been given by A, that was from the co-partnership property. Okay, co-partnership property. So, in that case, their legal heir may challenge that 5 lakh rupees whichever has been given in the form of gift after execution as a future gift, that will be not the part of the gift instrument, and there will be proper claim against B by the A legal heirs. So, suppose A legal heirs are X, Y, Z. So, X, Y, Z can claim over these 5 lakh rupees, okay, because these are the part of the future gift. Okay. So, in that way, even in case of actionable claim is treated as existing property, but within actionable claim there may be possibility that there are certain future, because suppose actionable claim about take the example of rent, okay, or any kind of encumbrances over certain property. So, that may be continuous one. Okay. So, rent is coming in every month. So, it has been said that if that kind of the gift has been given, that okay, for 1 year you will take that amount of money which are coming into the form of these claims, then that will be valid one. Okay. That will be valid one, because this claim itself is in existence. Okay. So, in that way actionable claim may be the part of that, and it may be the part of the gift also. Those claim which has been already arised on the date of, not those claim which will come in future. So, not prospective claim will be not the part, but actionable claim, those who are the at present, that will be the part of the gift itself. Okay. So, actionable claim is an existing property, and this existing property will be the part of the gift. Then mortgaged or leased, a mortgaged or leased immobile property may be gifted. Okay. This may be possible that here mortgage or leased immobile property may be gifted. Just I told you that that means rent and all. Okay. So, there is a lease property and something is coming through that lease, that may be the subject matter of gift. Mortgage property also may be gifted, but right of once the lease property and mortgage property is going to be gifted, then that is not only the lease is going to be gifted. Okay. Lease property is going to be gifted. Keep in mind, that means whole ownership is going to be gifted. Just like A has kept a mortgage of X property. Okay. So, whenever A is going to gift X to Mr. B, and suppose it was kept, mortgage was kept with Mr. Y. So, if A is going to gift X property to B and it is a mortgage property, so the mortgage amount okay, mortgage amount will also go to this B. So, B will be in place of A, B will be in place of A. Why? Because it is a complete gift without consideration. So, now B will take the responsibility, knowing that knowledge must be there that what are the amount and all. If B will not know that it is a mortgage property and then it will be given and he will accept just like that it is a free from all encumbrances, then it will be null and void. So, if the B is knowing that this is the mortgage property and then he is accepting it, then B will be in the place of A and whole ownership of X will be transferred to B. So, B will be the owner of A and whatever the liability of A had against Y, that will be shifted to B and B will have all liability against Y. In the same way, it will happen to the lease also. Okay. So, only the mortgage right is not going to be transferred, lease right is not going to be transferred, it is the transfer of the property as a whole and whatever the owner, that means here in case of mortgage property mortgagor, in case of lease property lessor, whatever they had right as a owner, that is going to be shifted and whatever they had obligation against mortgagee or lessee, that is also going to be shifted and B will be going to perform those rights and duties. Okay. Then gift of a part of joint family which failed to share of the donor under preliminary decree of partition was held to be valid. Gift of a part of joint family which failed to the share of the donor under preliminary decree of partition. I told you, I given the example of this in the beginning itself, that if I have share in a house of 25%, then I am entitled to gift that 25% to anyone, okay, but not more than 25%, okay, not more than 25%. So, gift of a part of joint family which failed to the share of the donor under the preliminary decree of partition, that can be done, that can be gifted and that will be the valid gift. Then next portion is delivery of possession. Okay. Delivery of possession is not necessary just at the time of transaction. Okay. Delivery of possession is not necessary just at the time of transaction. So, what it says that it is not necessary for the purpose of symbolizing acceptance to show that possession of immovable property gifted under the deed has been delivered. All that is necessary to show is that the things presented by way of gift were accepted by the donee. That means acceptance of gift is more important than the delivery of possession, because possession will come in future, that is not a problem. Okay. Possession may come in future. It is not like sale that just after it must be going to the possession, okay, because the transfer of possession in sale is very important criteria for completing it. But in case of gift, it is not so much important. Okay. But at the same time, because whoever is going to gift, the donee will not enjoy the benefit of that property unless and until he is going to get the possession. But it is not so essential criteria that it will not be a valid. So, it has been said that the more importance has been given or emphasis has been given that whether the donee is ready to accept the gift, whether the donee has accepted that gift or not. If the donee had not accepted gift, then transaction is not complete. Okay. Here it is a without consideration, and in case of without consideration also, if the donee has not accepted that gift, then it will be not a valid one. That is only one part has been done, the second part, that is later half part has not been completed, and in that way it will be not treated as a completion of gift transaction. Okay. So, construction of gift deed. Intention of the donor can be ascertained only by the reading the document of gift as a whole. Construction of gift deed is very important, especially in the case of the immovable property. In case of immovable property, it has been said that irrespective of the amount, because in sale that was in immovable property there was a restriction up to 100 rupees. But here in case of gift there is no such kind of restriction over the price, okay, or value here. So, value whether it is more than 100 or less than 100, it is completely immaterial. If the property is immovable property, then in that case this deed is important and registration is important. Okay, registration is important. So, what it says that whoever is going to gift, okay. So, why he is going to gift, that must be mentioned. Mention in the sense that whether it was why it is necessary condition, intention, because voluntary action is an important criteria or essential of gift. Okay. If there is no voluntary action, that means if it is not free consent, then the agreement will be completely void. And generally it happens that whether the person has gifted immovable property within the Hindu family itself, okay. So, at the end the person was under certain type of coercion, or there are certain kinds of fraud was committed, and any gift of immovable property is the result of not free consent, that must be checked. Okay. So, whoever is going to execute the will, he will have to prove that okay, this was the result of the free will of the donor, and there was a clear cut intention to donate this property, whether it is movable or immovable property, to the donee, and there is no such kind of any coercion or undue influence, and it is a very, very important part within the gift. Okay. So, that must be very clear. So, the voluntary transfer without consideration. So, the gift must have been made by the donor voluntarily, okay. And when it has been made by voluntarily by the donor, then it will be taken into consideration all those provisions of the Contract Act which suggest that consent is not free. Okay. It should not be a fraudulent consent, it should not be the result of undue influence, it should not be the result of this coercion, it should not be result of the mistake of fact. Okay. So, all these things should be taken into consideration at the time of determining that whether the gift was a proper gift or not. Okay. So, the voluntary action of the donor is very, very important factor at the time of considering the execution of gift. So, for example, it has been given here where a gift deed was executed by a lady and her son under the threat of her husband that he will commit suicide and they will not gift their property to his brother. The gift was held to be done not a valid gift. Okay. So, a kind of coercion was created, okay. Kind of coercion was created, and due to that coercion this gift was created. In that case, this will be not a valid gift at all, because when the consent is not free, okay, then this is the you can say this is the basic so fundamental in gift, that if the consent is not free, then it will be violate the all the procedure of gift. It may be the movable property, immovable property, okay, without consideration and all, but the consent is very crucial test. Then another case is of Parda Nasin lady. Okay. So, if Parda Nasin lady is going to do the gift, then how you will see that whether there was a free consent or not. Okay. So, if a gift is made by, this question came before the court, before the Odisha High Court in Kishore Ray Thakur BJ versus Basanti Kumar Das. Okay. So, High Court said in this case that if the gift is made by Parda Nasin lady, okay, it must be proved beyond doubt that she executed the gift deed voluntarily. Okay. If the plaintiff is an illiterate or Pardanasin lady, yet the defendant must establish the fact that plaintiff executed the document after the document was read over and explained to her, and she also understood that whether no fraud was played upon Pardanasin lady, the gift deed was held to be void as the contents were neither read over to her nor explained to her, which would show that she executed the deed after understanding its content. So, in case of Pardanasin lady, there is more caution should be required in this, okay, that it is very difficult to identify or to ascertain whether there was a free consent on the part of Pardanasin lady or not. Because Pardanasin ladies generally those ladies who are generally cut off from the society, cut off, that means they are within the family and they go outside with within they used to remain within parda. Okay. So, that means, and if she is illiterate, then the degree will become more higher. Okay. That means, whoever is the Pardanasin and illiterate, then before gift, before execution of that deed, everything must be explained so clear that that lady would be able to take decision through those writings after understanding all the consequences and all, that now she is going to make that gift. Okay. That means, rule is very clear that in case of Pardanasin lady, in case of illiterate person, that means things must be explained properly, so they can take their own decision. Okay. So, this is the safeguard has been provided for what purpose? Only to assure that there is free consent coming from the side of the donor. Otherwise, if there is any doubt or foul play or fraud, okay, because there are maximum chances of fraud or foul play in these kind of cases, okay, that she would be not able to understand the things whatever written. And this is not about only the Pardanasin lady, it may happen with any illiterate person also. First, because the language of any deed is a legal language, whether it is in English or in any vernacular language, it is tough, generally it is tough from the ordinary language of that particular area. So, even after reading before that lady or that illiterate person, even male person, it must be explained properly that what is the meaning of this. Sometime even educated person are not able to read the legal language, legal document with the proper meaning. Why? Even it is written in the vernacular language. Reason is very simple, that there are certain kinds of terminology generally used under the legal document. So, those terminology must be explained, and then only as well as consequence should be also be explained, then the person will take a kind of decision, free consent decision, that whether whatever he is going to make a gift is a proper gift, gift will be there, otherwise it may be challenged later on. So, just like it is a kind of free consent, okay, that free consent, informed consent, that you are informing everything about the gift deed, and then the person is, donor is going to take the decision over that, then it will be treated as a free consent under this. Then next important point is mode of transfer under section 123. For the purpose of making a gift of immovable property, the transfer must be effected by registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. Okay. That whoever is going to make a gift. Okay. So, I told you already that registered instrument is very, very important. Price does not matter here. That means, the value of the immovable property or movable property is immaterial. Okay. there must be this in case of this immovable property, price is completely immaterial, because in case of movable property it is delivered either by the registered instrument or by delivery of the possession. But if it is immovable property, then registration is must, and must in the sense that it must be signed by the donor, and before signing that there will be the requirement of explaining all those things for getting the free consent. This free consent is for the signature that okay, whatever you are going to gift, these are the items, these are the plots, these are the house, okay, and in this way you are going to gift it. So, before taking signature everything must be explained. If the person is illiterate, then thumb impression, or on the behalf of donor, or and attested by at least 2 witnesses, and witness will attest what they will attest, that before them the donor is gifting this property, as well as at that time they will assure that okay, this person is completely given, this person is a sane, that means within full sense he is giving this gift, and things were properly explained to her or him. Then after this signature has been made, and for that purpose to witnessing these things, 2 witness will sign the document. So, for making the gift of movable property, the transfer may be effected either by the registered instrument or aforesaid or by delivery. So, if you are going through the registered instrument, then again you will go by this process, otherwise mere delivery of possession will serve the purpose in case of movable property. So, gift under Mohammedan law. Okay. It says the declaration of gift by donor first of all, acceptance of the gift by donee, delivery of possession if possible, that is mainly in the case of movable. The provision of 123 do not apply under Mohammedan law, as therefore a registered instrument is not necessary, because they have their own personal law, and within that Muslim personal law govern the rules and regulation with respect to gift. Okay. So, TPA provision of 123 does not apply in gift according to Muslim law or Mohammedan law. So, according to that, it has been said that the registered instrument is not a necessary criteria. Under Islamic law, there is no requirement of a registered instrument even for the immovable property. So, they can do the gift okay, according to their personal law, and there is no requirement of registry of the instrument of gift. So, 123 is not applicable, mode of making gift is not applicable. Registration of gift deed, okay, that is also important part of this gift deed. So, registration of gift deed is in the case of gift of immovable property, registration is compulsory, but it is not necessary that it must be registered by the donor. Okay. Immovable property registration is compulsory in case of immovable property, but it is always not necessary that it must be registered by the donor himself. Registry is must, but donor will only do this, it may not be, even the donee may register it, or any person on the behalf of donee may register it. Okay. Registration of gift deed of immovable property is compulsory irrespective of value. I told you already that whether it is 100 or more than 100, it is immaterial. In sale it was necessary. If it is more than 100, in below 100, it was not necessary. But here in case of gift, even immovable properties which has been the gifted, it is below 100 rupees, even then registration is must. And these days, because it is a act of 1882, that time 100 rupees had more value, there was possible of immovable property within that rupees. These days in 21st century, within 100 rupees immovable property is not possible. Okay. So, for that purpose that is not applicable, but whatever is the value of immovable property, it is not necessary here. There is requirement of registry of the gift. Okay. Then once the deed of the gift is delivered to the donee, even before it registration, gift become irrevocable. Once the deed of the gift is delivered to the donee, even before its registration, the donee will do the later on registration, gifts become irrevocable. That means, once the deed has been reached into the hand of donee, then it cannot be revoked, okay, irrevocable. Once the deed is executed and the gift is accepted during the lifetime of the donor, the deed may be registered even after the death of the donor. So, once it has been accepted during the lifetime of the donor, that deed may be registered later on also after the death of the donor. Then the last part of the deed, that is suspension or revocation of gift under 126. When gift may be suspended or revoked. Okay. So, it says that this gift is a transfer of ownership without consideration, and a deed of gift once executed and registered cannot be revoked unless it can be showed that the mandatory requirement of the section were not complied with. That means, when the mandatory section or mandatory requirement of this section has been applied and gift has been executed, then it cannot be. So, a gift can be made subject to certain conditions. It is necessary that these conditions must be valid condition according to the provision of this act, and suspension or revocation of agreement, gift may be suspended or revoked by mutual agreement between the parties, donor and donee, not one sided. Okay. That means, once it has been executed, then donor cannot revoke it, and once it has been executed, the donee cannot say that now they will not accept it. So, they may agree that on the happening of the specific event, gift may be revoked, but this specified event must not dependent on the will of the donor. If the happening of the event is dependent on the will of the donor, suspension and revocation of the gift will be void. That means, it should be beyond the control of the party, beyond the control of the donor, then only it will happen that certain condition may be fixed, and if that is happening, they will come under the agreement. If that will happen, then it will be revoked, then it can be, but that happening is not within the control of the donor. So, it is necessary that agreement to suspend or revoke the gift must be made at the time of making the gift, otherwise gift will become absolute. That whatever this condition you are making, happening of a specified event, this event must be made, this event must be declared, this event must be mentioned at the time of making of gift. Okay. If these conditions are not mentioned at the time of making of the gift, then later on, once it has been executed, then there is no remedy in the hand of this donor or donee. Okay. So, next is revocation by rescission. So, a gift may be revoked in any of the cases which, if it were a contract, it might be rescinded except for the want or failure of consideration. A contract may be rescinded in the following ways, that is coercion, undue influence, fraud, misrepresentation. That means, there was no valid consent, because what is this? I have already discussed earlier that in these circumstances, if there are these circumstances are going to affect the decision making power of the donor. If there is a coercion, if there is undue influence, if there is a fraud, if there is a misrepresentation, then decision making is not free, then the essential requirement of the gift will be not valid. Okay. So, in Kanu versus Kalu AR, Rajasthan High Court had referred this. So, exception is that this section 126 provide an exception in favor of transferee for consideration without notice. 126 provide exception in favor of a transferee for consideration without notice. Consideration without notice. Transferee, that means donee, for consideration without notice. It provides that nothing contained in this section shall be deemed to affect the right of a transferee for consideration without notice. Okay, that means there was, because a gift is without consideration, but here the transferee was with consideration and without notice. Therefore, if the gift property has passed into hands of transferee from the donee without notice of the right of revocation or suspension, but for value, the right of revocation and suspension cannot be exercised against him. Okay. So, it says that this 126 is a kind of exception. Exception means exception of revocation. Okay. So, what it says that that means an exception in favor of transferee for consideration, something which has been transferred to the transferee with consideration and without notice of the gift. So, it provides that nothing contained in this section shall be deemed to affect the rights of the transferee for consideration. Okay. Or you can say here the purchaser without notice. So, if the gift property has passed into the hands of transferee from the donee without notice of the right of revocation, without the notice of right of revocation or suspension, but for value, the right of revocation cannot exercise against him. Clear? That means, if A gifted property to B, B is the donee, given it to C with consideration for 4,000 rupees, whatever it may be, just example, and because C has paid this 4,000 rupees, okay, so he is the transferee with consideration, and because he was the donee and donee had a right to revocation, so and this right to revocation has not been communicated to C by B, then B will have no right of revocation at all. Okay. So, in that way it works. So, this is only one exception has been given under section 126. So, this is all about the law relating to gift. Okay. So, I have tried to cover the definition, essential, mode and revocation. One question has been here asked whether the charity or donation to religious dedication is gift or not. It has not, court has not accepted it as a gift. Okay. Dedication of his property by a Hindu for religious or charitable purposes was held to be neither a gift nor a creation of a trust. A religious endowment does not create title in the property in strict legal sense. So, court has said that dedication does not require a registration. So, it has not been treated as gift. Okay. So, this just I have mentioned for just additional knowledge here this, that whether this charity or donation will come in the category of gift or not. So, court had accepted that it is not a gift. Okay. So, it is all about gift. Thank you. Thanks all.